My name is Steve Black. I'm a law professor at Texas Tech University, and I work with the Lava Institute. And for the next few minutes, we get to talk about the really exciting topic of legal issues with respect to SEC disclosures. And there should be a wave going on and cheering and everything, and we'll see how fun we can make this. A couple of housekeeping matters. If you have questions, and I love questions, if you want to do it during the presentation, please come up to the mic so that we get a recording of it. Everyone can hear your question. If we don't get to your question during the presentation, but it's burning a hole in your pocket and you really need to ask it, I'll stick around afterwards, and my contact information is on the last slide, which means we need to make it to the last slide, and you're welcome to reach out to me later, and I'm happy to see if we can come up with an answer to your question or at least make something interesting up. So here's the disclaimer slide, and I'm just going to point it out to everybody, and it's in small font, so you'll need to, because that's how lawyers like to work, and we're going to move on from there. And I think this is one of my favorite images that I have put in one of my slides. What in the world does this have to do with anything? So for those of you that don't recall the year 1929, that's where we're going to start. October was not our best month. And what had happened was there were a whole bunch of companies out there with a whole bunch of speculative investments, and people invested and were taken. The stock market crashed. It's a bad day in U.S. history. As a result of that, Congress decided to pass a couple of laws primarily to see if we could avoid having the stock market crash again. And the focus of those laws was to provide enough information to the investing public so they could make a decision and not have to rely on somebody saying this is completely safe and we're going to make 500% return on your investment, everything's going to be good. So the whole impetus of this is complete, transparent disclosure. Hold on to that thought as we move forward with the slides. So I've assembled 10 legal issues, and if we've got time, I think I even have a bonus one. They're in no particular order except that I numbered them this way. So let's start with number 10. And it's a frequent question that I get asked, what in the world do I need to disclose? All right, it's a great question. Let's start with it. The new regulations that were finalized last year add item 1.05 to the disclosures that public companies need to make. So item 1.5 asks that a registrant who experiences a cybersecurity incident, and believe you me, there is a definition of that, and we're just going to gloss over it for today because I think we have a sense of what an incident is going to be, needs to disclose the material aspects of the nature, the scope, and the timing of the incident. All right, so I've got nature, scope, and timing. And in addition, the material impact on the registrant, including the financial impact and the operational impact. All right, so what do I need to disclose? Material aspects of the nature, what happened, the scope, how big was it, how small was it, timing, when did it happen, how long it had been happening, those types of things. And then also the material impact on the financial condition and results of operations. All right, so I'm kind of a curious individual, and if I were investing in your company, what do you think I would want you to disclose to me? And the answer is you're not necessarily looking at me, because the term materiality and the things that we're trying to look at, for me, I would like to know everything you got. And that's not necessarily the balance that we're trying to draw here. We're really looking at a balance between, can you tell me everything that's happened? And there's a danger to that, because if you tell me everything that happened and how you know it happened, I may just decide to hack you myself. I'm not doing that, right? If I speak hypothetically, everyone's okay with that? This is not Professor Black up here saying I'm about ready to put on my black hat and come attack you. So that's one end of the balance, that I would like to know everything that you know. On the other end of the balance is we really don't tell you anything at all, right? Something happened, it may have been big, we'll get more information to you later. That really isn't telling me anything in order to make an investment decision in your company. So we're doing this balance between telling you enough and telling you too little. All right, some of the instructions that the SEC has provided. And this is a long document, and there are a lot of examples of, yep, this is material, yep, this is material, yep, this is material. In response to companies coming back and saying, wow, we just think you've gone way too far here, is this item number 4, which says a registrant need not disclose specific or technical information about its planned response to the incident or its cybersecurity systems, right? You don't need to give them the keys, say, come on in, take a look around, see if there's anything you want to grab. We don't need to do that. But we do need to make this balance of what I am disclosing. Okay, number 9. If we go back to number 10, you see that we have to disclose the material aspects of the nature, scope, and timing. So I get a lot of questions, what in the world does material mean? And that's a great question. If I've got a bunch of law students in a classroom and I'm going to pick their brains and make them, really rethink their career choices, can you give me kind of a, Cliff's Notes versions of what materiality is? Yes, right? If no one says that Professor Black told us that today, let me give you the Cliff's Notes. Number 1, who is it important to? Number 2, what or why is it important? And number 3, when was it important? We're looking to ascertain the disclosure of important or significant events. And then I get this question, does that mean that if it's over, right, and how much is a lot of money to this crowd? I usually ask my law students, you want to know what the answer is? $500. They're starving. They just had to buy books, and those books are thick and expensive, and they say $500. That's not the touchstone that we're going to use here. So then I get to talk with some individuals. I don't talk with Elon or with Jeff or any of those people, right? Because the answer would be, well, I don't know. Can we put a B with it or a T with it? Billions or trillions? Because that would then be significant for us. And the answer is that's not the touchstone of materiality. The touchstone is, for an average investor, a reasonable investor, would they consider this to be important now? Well, goodness, right? How do we ascertain that? Because reasonable investors just don't pop out of the woodwork and say, here I am, ask me some questions about whether it's material. So let's take a look at what some of the courts have said. This is the U.S. Supreme Court here, and the interesting information is going to be in orange, and then we're going to have to parse through it. An omitted fact is material, and I'll come back to omissions in a minute, if there is a substantial likelihood that a reasonable shareholder would consider it important in deciding how to vote. All right, substantial likelihood. Black, that just sounds like wishy-washy language. Congratulations, we're understanding each other, right? These are not hard and fast rules. If you're looking for hard and fast, I have to report this, I don't have to report that, you're looking for another topic. Materiality is really a sliding scale. It's a balancing act. It's a, have I disclosed too much? Have I disclosed too little? Continuing on, there must be a substantial likelihood. Again, what's substantial? Is that 30%? Is that 47%? Is that substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information? Mixes of information. Professor Black, you're just a party in a bucket. I kind of am. So that's what the courts are telling us that material means. No one's jumping up to the microphones. We're okay with that. We've heard that a lot. There are lawyers in the room. Everybody knows. We hate talking to you because you can't give us a straight answer. And it starts from law school, and that's where we go with this. All right, number 8. I like this one too. This is a dangerous slide. I was thinking about it as I was making this slide. Is it okay to put that on a slide? Okay. How long do we have to report? All right, so there are 2 things here. Number 1, after you have decided that the incident has material aspects to it. Okay, that's the first thing. That's the trigger. After you've decided that, you have 4 days to file your 8K. So, after the trigger, you have 4 days to file. It's that second one that then is getting us into trouble, and we're getting again into wishy-washy language, which is the bottom thing, a registrant's materiality determination, as if that's a party that we want to be invited to. Regarding a cybersecurity incident must be made without unreasonable delay. And in the original version of the rules, it didn't say without unreasonable delay. It had other language, and then we went, do we want to say positive or negative? This is what we've got. So, without unreasonable delay. If you take a look, because that's not a geeky thing to do, at other countries or other companies' disclosures since December, you will notice that there's a lot of immediate language. We discovered a breach and immediately, right? Well, what's that going to? It's going to, we acted without unreasonable delay. So some of the comments that the SEC opined on said, well, what if I have a committee that gets together to decide material aspects and they meet every other month? And the SEC said, stop, right? You don't get to do that. If this is a breach and it's ongoing, your materiality crew, whoever that is, and we're going to talk about that a little bit later, needs to meet without unreasonable delay. What's a reasonable delay? I have no answers today. You really want to know why I'm up here talking at all. But that's what we're looking at. So you'll see in the disclosures immediately, we got together, we made a determination, here's what we're going to do. We don't have all the facts now, but the 8K can be amended over time. So you can come out and say, here's what I know today, so that I'm meeting that without unreasonable delay plus the 4-day filing period. All right, number 7. This is really what I wanted to know. Will disclosing increase my company's risk or make us a target? Well, number 1, you've just publicly stated that you've been breached. So the answer to this is probably yes. Coupled with our knowledge that companies that make public disclosures, companies that advertise that they have cyber insurance tend to be attacked more than companies that don't. And if we were to think about an alternative to our careers and say there's a lot of money to be made as a criminal, and okay, disclosure for that right now, I'm not advocating that we do that. But we need to get in the mindset of saying, if I knew that there was a company out there that had suffered this type of breach, would I then try my hand at attacking them as well, because I know that they're down right now, right? They're trying to respond. And does that make them a little bit more wary, or does that mean that some of the doors are left unguarded while we're all running around trying to figure out who did this, what happened, what did they get? So, will disclosing increase my company's risk? Probably. If I'm saying that something happened and a reasonable investor would want to know, I'm probably in that risk category right now. Am I in a risk for increased cyber attacks? Time will tell. All right, we're up to slide number 6. We're having fun and going through this. What if the breach happens in a third-party system? Oh, I like this, right? It wasn't my fault. It really wasn't. Right? Yeah, it kind of was, because I chose friends and something happened to them, and I feel bad about them. Do I have to disclose that? We'll go back to the definition of what we have to disclose and what the standard is. If it's material to my company, to my organization, regardless of who caused it, then the answer is yes. With this caveat that I have up here, and honestly, I searched the internet for interesting throw somebody under the bus images, and a lot of them were just kind of creepy. I'm just going to let you know that. So I didn't use them, right? There were a couple of them that were a little bit gory too, and I decided let's sterilize it. So here's the reminder for you. Is the adage what goes around comes around? Is the adage that the bus has a reverse gear? Is the adage that I still have to do business with these people because they're in my supply chain? Is the adage, hey, right, we should be sharing information and presenting a united front to all those who want to attack us? Any of those might give you pause in terms of, do I need to disclose it? Probably. Does anything prevent me from calling that third-party vendor or partner and saying, hey, I realize this is going on. Would you be interested in collaborating? Is that an awful thing for the SEC's point of view? No. On the language that we're going to agree on in terms of our joint disclosure. And from my reading right now, that it does not get you into collusion, that does not get you into RICO charges, it doesn't get you into any of those types of things. Perfectly valid. If you've got friends and partners that suffer a breach, send them condolences, offer to help. And part of that may be, here's what we're going to say as an industry or as a group. This has happened to all of us, and here's how we're responding to it, and we're going to move forward. All right, I put this image together. My daughter called me and she said, I don't really get it, which is not a good sign. So, if I have to explain the image, here it is. For those of us that don't have these types of signs, the sign says, no pedestrian, that's PED, pedestrian crossing, use crosswalk, right? So this is commonly known as jaywalking. And I would like to say that I get a lot of questions about whether jaywalking is illegal. I'm really not going to do it, but here's an interesting social engineering experiment for all of you who are so inclined. Leave the building after my presentation, not right now. Leave the building, it's a beautiful day today, go watch what happens on the crosswalk, because here in San Francisco we've got nice crossing signs that light up green, and they've got accessible beeps and all those types of things, and every so often somebody decides to jump the gun and cross when it's not green. And the question is that an illegal act? Am I going to be led away in handcuffs? And I'm not your attorney today, so I'm not going to answer the question. If you do get led away in handcuffs, tell somebody so we can get video of it. Not that we're going to laugh at you, but that it would be really interesting on all our YouTube channels to watch that happen. So this one actually has a combo question. And the combo question is proposed by my daughter, so she gets 5.5. Number 5 is, what happens if we don't disclose? And then 5.5 is, what happens if we do disclose? Aren't those great questions? I love these questions. All right. Typically, there are 4 main enforcement mechanisms that the SEC can bring to bear for companies that fail to meet their duty of disclosure under the new rules. 4 of them. Should we go through them? Number 1, they can issue a permanent injunction. If you were crossing outside of the crosswalk, that's like the police officer standing there, pulling the really cool sunglasses, right? I need to get a pair of those. Pulling them down and just giving you the no, right? The SEC gives you one of those. What it is don't do that again. And you count your lucky stars that you got off so easy. So that's number 1. Number 2, they can order a disgorgement. That is a wonderful word, right? That may be my word of the day. Disgorgement of ill-gotten gains. In other words, if you didn't disclose, and there was trading in your stock, or your prices went up, or something happened, and you were enriched by the fact that you didn't say what you were supposed to say, the SEC can come back and say you have to give the money back. Okay, that's number 2. Number 3, the SEC can issue an order for those who were responsible for not reporting, or for those who reported falsely, or a whole bunch of other things, that they don't get to serve as an officer or a director of a public company again. Lifetime ban from the pool, right? It's like you go to Disney World, you break one of the rules, we're not going to let you come in the park again. Or a lifetime ban from a cruise ship, right? We've had enough of you, that's the lifetime ban. So that's number 3. All right, so far so good. I think I can live with all those. Give me your worst. What's number 4? All right. Everyone take out your pocketbooks, your wallets, your charge cards, all those types of things. If there's a penalty in one of the disclosure requirements, they start at $5,000 per incident. They go up to $100,000 per violation if you're an individual. If you're an organization, they start at $50,000. Wow, 5 to 50, and go up to $500,000. Well, okay, my business does, huge volumes of sales, that's a drop in the bucket. Oh wait, because I said that's per violation. So failing to say something today, and failing to say something tomorrow, and failing to say something the day after that, are those all separate violations? Okay, for those of you who are nodding yes, right, that's an awful law. Right? Every time you don't do something, we're just going to let it compound, and the SEC violations can start to get very large very quickly. And that's usually what we're worried about there, in addition to expensive litigation, the company's reputation, right? That perp walk, the SEC came for me. Right? It may not be the perp walk, but right, they've come for me, and now I'm in the news daily, and I hate being in the news daily unless it's about my charming personality, something like that. My insurance company may not cover SEC violations. Do you want me to say that one more time? That one's kind of a chilling one. You know those insurance policies, again, that are written in legalese and very small print? You might want to go check that again, because if there's an SEC enforcement action, you may not be covered. And that's kind of sad, because then that's coming out of my pocketbook. And then this question of, is the CISO, however we want to pronounce it, potato, personally liable? And this is the awful question that I get asked a whole lot. I've just gotten my first job. I'm in charge of all security for my organization. I'm feeling really good. And then somebody comes up to me and says, it's your job to figure out whether or not we need to disclose. And if you don't do it, whose fault is that? And that's just an awful type of thing. All right, 5.5. That's the question. What happens if we do disclose? All right, we have to have a little discussion about SEC and what the requirement really is. And I said it's material aspects. Material aspects are typically facts, but they also could be omissions. So you have to say something, but you also have to not say nothing. Did I just say that? I did. You want me to say it again, right? You have to not say nothing if it's material. So omissions can also be the subject of an SEC investigation. So if I do say something but I don't say the right thing, or I do say something and it was too big, what can happen? Well, the best that can happen is I disclose something that wasn't material. And there's a Supreme Court case talking about a circuit court case, and the Court of Appeals had said this: if you disclose something that wasn't material, you suddenly made it material. And the Supreme Court said, no, we are not going down that rabbit hole. That's an awful thing to have to consider. Makes my head hurt just a little bit that if I say something that wasn't important, it's suddenly important because of the fact that I said it. So 5.5 usually involves I said something I didn't have to, and we are seeing a whole bunch of precautionary disclosures. I realize that if I said it, maybe somebody would care, but the alternative is I didn't say it and the SEC is going to come after me. So I think what the safe thing is to do is to go ahead and say it, and then we'll worry about whether it was material later, and I'll deal with my shareholders saying we didn't know what the law was going to be, so we were playing it safe. And that's my best answer for 5.5 until we get to Macquarie, which came out in April. And in this case, we had a company that owned a subsidiary. The subsidiary stored liquid fuel products. And they had said, and okay, so help me out with this one because this is kind of fun. My company had said, we're completely compliant. And in this day and age and environment, I've got to be really careful about saying I'm completely compliant. But they had said that. And then a rule came out that regulated a certain type of fuel that they had with additives that they had been storing, and they didn't say anything about it. So now their omission of not saying anything about it rendered their original statement of we're compliant to be false. So your significant other asks you, I get myself in so much trouble with this, right? Significant other asks you, do you love me now, irrevocably, and forever? Sorry, right? Now we're awake. Yes, I do. Heart of my heart, I love you forever. And then something happens and that changes, and you don't say anything. If you ask me, are you in trouble, that's a completely different question. The answer is probably yes, and I'm not a relationship doctor. You're on your own there. Sorry about that. Macquarie dealt with the question of, am I under an obligation to report? Let me rephrase that. Can I omit things that I don't think need to be said? And the question then came up, if what you omitted rendered something else that you said previously untrue. The headache's starting again, right? Because then I have to go through and say, well, did I say it? Did I not say it? And all too often, the question is, who in my organization is in charge of policing all the things that we say? Who in my organization is in charge of policing all the things that I say? Frequently, if you're in charge of security, the other people in your organization feel that that's your job. And friends, I'm going to tell you, you're not getting paid enough to do that because you've got a whole bunch of people running around saying things about the security of your organization, including for those of you that have a sales team over in the other building. Because I don't know what they're saying right now, but we probably ought to know if that's what my organization is going to hold me to. So here's the pedestrian crossing. That actually took way too long to explain, but that's what we're talking about here. What happens if I do disclose? What happens if I don't? I'm up to, what are my people saying? And let me give you a twist on this. This quote is from the SEC. And this is in their enforcement action. They said, public statements about its cybersecurity practices and risks painted a starkly different picture from internal discussions and assessments about the company's cybersecurity policy violations, vulnerabilities, and cyber attacks. Can I translate that for you? What you said publicly was not what you were saying in the building. So the SEC thought it would be fun. Anybody here from the SEC and I'm just offending you or painting a target on my back? Good, I work for a public university. I should have some protection there, and right, I make no investment decisions because every time I do, the stock prices drop. So there's that. Public statements. What you were saying outside the building didn't line up with what you were saying inside the building. So the SEC started subpoenaing your internal emails. Anybody use Slack? They wanted records of that. If there were memos, they wanted records of that as well. And then I get asked a whole bunch of questions. Is there any privilege for that? Can we keep that, out of... My security team talks about a whole bunch of things. Right? What we say to the public is everything's fine and happy, and then in the conference room later they're like, we don't have enough money to do what we need to do, and right, we're losing people and all kinds of things. And the question is, if we're saying that, does that make our public-facing statements false? Now, on the one hand, you could say, yeah, it kind of does. On the other hand, we talk about things all the time, and as an organization, are we allowed to say, overall, we do a pretty good job at security. Overall, we follow industry practices. Overall, we're one of the leaders in our supply chain. Overall, our security practices are exemplary. That's a good word, too. And then in the building, right, we say, we need more budget. We need more people. We need more training. We need the latest cool thing that we can install that's going to protect us, and we need a whole bunch of AI. And I'm not even going to start on AI and whether that makes things false or not. So, what are my people saying? It's an interesting question right now, and I don't have an answer for you. If the government can come in and take what you say in private conversations inside the building and then use that to show that perhaps your public-facing statements are not what they should be, that's a dangerous place to live. For those of you that want absolute certainty, then you should move your security teams under legal, and that's not going to be a problem at all, let me tell you that, from a legal point of view. Right? We like our legal teams, but they are clueless when it comes to that. Did I say that out loud? I did. If you're a part of the legal team, you can come argue with me later. I will completely agree with you. All right, so what are my people saying? That's a legal issue. I told you that we're going to come back to who is on my materiality team, because remember that the new rule says I've got a trigger. I need to make a materiality determination if there's an incident. And I have to do it without unreasonable delay, which means that as soon as there's an incident, some team has to be activated to start looking at the facts to determine whether a reasonable investor would find this information important, and then try and figure out what in the world we're going to say about it that's not going to expose us to further attacks, that's not going to expose us to further litigation, that's not going to make the CFO cringe because our stock prices are going to drop, and that is not going to be false under any definition of the term. My exams have already been given, but that would be a fun final exam for my students, right? Here are your parameters. I need you to disclose some information, and I'm going to be judging you in 4 or 5 impossible different ways. All right, so that's the team that needs to be engaged, and I do have a lot of legal teams that come to me and they say, great, so are we part of this? And my answer is, I certainly hope you are. And they said, great, so we'll just grab somebody and say, bring us up to speed. Okay, for those of you who have been through incident response, is that the time that you want to be bringing somebody up to speed? Typically, when does it happen? Weekend or, Tuesday morning-ish when you've got all kinds of time. It's on the weekend, I'm already tired, my team has been working for 72 hours straight, slogging through logs. Is that what we usually do? And then my legal team shows up and says, hey, how's it going? Right? I feel like killing them, or at least rendering bodily harm to them. That's not the time that I want to do it. So if you haven't been having a discussion with your legal team to bring them up to speed when you've got the time to do that, that's great. If you are legal team, can you get up to speed when it's not an emergency? I know we train you to read really, really fast, but this isn't the time to do things off the cuff. All right, this quote here, the audit board study found that 75% of chief information security officers, hey, that's us, are involved in the SEC's cybersecurity breach disclosure process, compared with, where were the CFOs? Aren't you the ones dealing with risk and materiality on a regular basis? And the answer, too sadly, is, we think that this is your job and not ours. So, who do I bring on my materiality team? I usually nominate the CFO. You get to come with us because we have some questions for you about materiality, and it's probably going to affect our stock prices, at least temporarily. Who else am I going to choose? I've got legal, I've got the CFO, I've got the number of my team who are really smart because I need to know what's happening. All right, let me go back through that. That does not mean that I need to do this within 4 days. That does mean that I need to make a materiality determination without unreasonable delay. And let me tell you some of the questions that come up in these disclosures. Disclosure reads, last December, right? What month is this? May? So it's May, April, if I can count backwards, March, February, January, 6 months ago-ish, 5-6 months ago, we discovered. All right, what's the problem there? It's looking like the delay in when you said you discovered this and when you made the materiality determination seems to be getting a little bit long in the tooth. And the problem is that we're judging you from an objective point of view after the fact with 20/20 hindsight. I don't know about you, but my crystal ball does not work particularly well. So in the moment, in the heat of, hey, we've been working on this for 72 hours, I'm trying to decide 6 months from now, will somebody think that what we said or didn't say was important to their investment decision? And that's the job that you're being asked to do. So, all right, who's on my team and what do I need to do to make sure that they have all the information? And do I tabletop this? This is a fun thing to tabletop because, number one, there are no right answers. We had a panel earlier and we were asking about some of the questions and we completely disagreed, which probably isn't a good thing because depending on who's running the show, we would have disclosed or wouldn't have disclosed and gone from there. All right, this one doesn't come up a lot. It is entirely fun. Did you know that the SEC has a whistleblower program? This is probably the part in the presentation when I start, crap, right? What do you mean that? That means that if I don't say something, but somebody in my organization smells blood and decides to say something, can they go to the SEC and say, I think there's information here that you should be aware of? Yeah, traitor, snitch, right? And all these things are going through my mind. And so what do? I go to HR and I say, we should dismiss this person right now because they're a danger to the organization. All right, just a few minutes, we can take notes on this. Let me tell you what the SEC does not allow you to do under the whistleblower program. Number one, you cannot discharge a whistleblower for the reason that they blew the whistle, right? If you've got other things against them, put on your tap shoes, because it's a little bit dicey there, because once they've made the disclosure, right, it looks like that's what you're doing. You cannot discharge them. You cannot demote them, right? I'm sending you to the remotest Arctic wasteland that our company has, because I don't want to see your face anymore. You cannot suspend them, with pay or without pay. You cannot harass them. You cannot discriminate against them. That's kind of a broad term. And if you do any of those things, not only can they ask the SEC to intercede, but they also have a private right of action to come sue you. All right, let's just think about that one for just a minute, because none of us watch the news. We're not watching any trials right now in terms of witnesses and anything like that. But let's assume that we did have an incident. Let's assume that we did or did not disclose some facts. Let's assume that somebody decided we hadn't gone far enough and blew the whistle, and then we did something to them to demote them or discriminate against them, and now there's a lawsuit. Forget the SEC for a minute. This is a private lawsuit, private federal lawsuit, and now they get to take the stand and tell their side of the story. Without my control. I can't edit what they say. I can't do any of those other types of things. That is a nasty place to be, but it gets better. Because if they win, they get double back pay plus attorney's fees. So, for those of us who haven't considered whistleblower programs before, I'm just going to throw this out there because we already weren't sleeping well, and we might as well all be up at 2 in the morning thinking about this. If you've got individuals in your organization, now do I need to think about who's going to say what and when? Wait a minute, is that my job? I'm sure that's HR's job or somebody else's job. Can't be my job because I've got too many things on my agenda already, and I'm trying to keep us all safe, and you want me to worry about this? I really didn't, but I was looking for something scary, and this one fit the bill. Should we go someplace nicer with slides? That sounds like fun, right? What else have you got? Maybe this doesn't apply to me, right? You said, and I heard you say it, right? You're on tape, Professor Black. You said publicly traded companies have this duty. I am not publicly traded. I bailed on that. I work for a startup. We're all our stock, and we haven't gone public yet. I'm hoping we don't because, right, all kinds of things. I don't have to do this, correct? Answer, true. You're not responsible to the SEC or the public. If you have cyber insurance, will your insurance provider ask you to disclose? If you have partners with whom you share data, or maybe you are the partner and you've got people who are in your network for valid reasons and everything else that I've done to them, are you going to make them disclose if they've had a material cyber incident? And here's the nice thing about a contract is you can define material any way you want to. So if you like the $500 limit, go for it if they'll accept that. Right? If you're playing up with the big wigs and 500 billion sounds more your style, you can do that. You can define material any way you want to. But if you think that this doesn't apply to you because I don't work for a company right now, the SEC knows what's going to happen as soon as they put out a rule, is that other companies will adopt it by contract. Other industries will adopt it by contract. If you deal with other governments, they will adopt a variation of these rules, and it may not accord with what the US SEC is looking at, but it may be that you have to disclose as well, and I apologize for the compliance nightmare that that's going to cause. But this is part of what we're doing, and that's the road forward, and I told you my crystal ball doesn't work, but this part of it I'm pretty sure on, that we're going to see more and more requirements for disclosure, which means, working backwards through the slides, that means that I need to have a team that is ready to ascertain when I have an incident, how important was it, to whom is it going to be important, right? That could be investors, that could be other stakeholders, that could be if I'm looking to merge or be merged in the future, that could be industry groups and others who may want my company, that could be insurance companies, and I hate to say this word because it's a four-letter word that begins with a J, juries, right? I wonder what's important to a jury about what I said or didn't say, and those are all going through my head, and that's an awful place to be. All right, well, those were 10, and we could end right there with a nightmare of it, or should we keep going just a little bit further? You want bonus time? Okay, bonus slide, here we go. Just because I like that one, seems good. So here's the question for you. Do I have to report a cyber incident that happened to a foreign subsidiary? Because, all right, Professor Black, you're a lawyer. Let me tell you a little bit about jurisdiction. The laws only apply if I'm in the jurisdiction. Laws only apply if I'm in the jurisdiction. So if I have something that happens outside of the jurisdiction, I am free and clear, and I like that answer, kind of. So, what do you want to tell me about? Radiant Logistics. Who? Well, let's just pretend that you have a logistics company. And the thing about logistics is that mostly you are worldwide in nature. That's kind of the name of it, right? It's hard to be, I'm a logistics company, but only for Texas. Although I know a couple of those, right? Because to Texans, the world ends and, doesn't exist outside of Texas. It's hubris. We get it. We understand it. Radiant is worldwide. Radiant had a problem in one of its computer systems that only affected anyone here from Canada. I've been picking on Canadians this whole conference. My apologies, because y'all are the nicest people. But here we had a problem in Canada, and specifically they said in their disclosure, none of our US operations were affected in the slightest. We were perfectly okay with that. But if we're a logistics company and something goes down in Canada, it affects everything else. And going back to the definition of materiality, would a reasonable investor want to know that A, we had been breached at all somewhere in the world? And the answer was yes. Can we go back further? Sure, because a lot of third-party actions may not happen in your US base of operations. It may happen in Latin America. It may happen in Europe. It may happen in Asia. Wherever there is a vulnerability, you may be attacked there. And then the question comes, all right, number one, do I need to get that team together to decide whether it's material for US purposes? And if so, what do we need to say and how do we need to disclose it? That's a lousy bonus slide altogether. So my answer, do I have to report a cyber incident that happened to a foreign subsidiary? Possibly. Because I'm doing business around the world and we're one big happy family, what happens to one happens to all. I need to take a look at it. All right, bonus number 2, I didn't include this slide, but I'm just kind of tickled by the whole question, so I'm going to ask you this. And this is one of those that my panel earlier disagreed on, so here's the scenario for you. I woke up this morning, I just had a bad feeling, so I started looking at all my AWS configurations, right? Just kept me awake, so I figured, let me get up and just make sure that all the locks are locked, all the doors are closed, the barriers are up, and I find a data store that is misconfigured. All right, so I call some of my really smart team members and I say, come on over here, take a look, and tell me if anything was taken. And after an exhaustive investigation, we determined that nobody found the fact that we left the door unlocked. So we tiptoe away from the problem. This is my interpretation of it, right? That's my job. I'm there to find out if anything is wrong. And I found out something was wrong, and I got lucky today because nobody else found out about it. So I patched the problem, right? And we all went to lunch. So here's the question for you. Is that something that I need to disclose because it's material? Or is that something that, hey, I found out about it, the no harm, no foul rule? If you're going to cite that in court, go ahead and use my name. It's Black's no harm, no foul rule. And we'll see how the SEC likes me after we do that. Because I'm guessing, and this is what my panelists said, the SEC is not going to go for that. And my answer is, would an investor care that I'm doing right? And so let's spin it, right? A, were we breached? Yes. No. What did we do? We made a mistake. Is that a material aspect? Well, all right. If I put it that way, yes, it sounds like it. So let's spin it a little bit, because some of us are lawyers and I'm a lawyer and we can spin language, because that's what we're talking about is disclosures and words and language, right? Here's the spin. I was doing my job. I woke up this morning, I was checking locks and doors and making sure, right, I've got my nightstick and my flashlight, and I was going through and I found something. And then I did an exhaustive investigation. I found that nothing had been taken. So I fixed the problem and went on my merry way. I was doing exactly what I need to do. Is that something that I need to tell you? We're good, right? We told you. Some of you are not buying it, which is really scary, because you may be my reasonable investor, in which case, if you think it's important, then I probably need to disclose it, and that's where I'm going to end with. Any questions that I can answer for this group? All right, while you're thinking of the questions, here's what you need to take away. All right, next week. Next week I want to get back to work. I want to take a little break. I'm going on vacation. You ought to take a look at what disclosures you have made and what you've said. You should start having those conversations with your materiality team. If you're not best friends with a lawyer, you're missing out on a really rich relationship. Not that they're going to charge you, but right, a rich relationship with somebody who's intellectually curious and looking out for your best interests. And then you should start documenting these answers and figuring out what you're going to say if there is a problem in your future. I am wishing that there are no problems in your future. Your organizations are locked down tight. But here I promised I would give you my contact information. I will stick around and answer questions. You're free to reach out to me later. Otherwise, if I can answer questions now, we have a few minutes and we'll do that. Hey, thank you for the applause, but we're going to try that again. I was asking for questions, not for you to make my head bigger. So we'll go with that. Yes?
So should an organization create a policy or definition of an internal definition of materiality? And would that suffice for the SEC?
So the second question, the answer is not necessarily. The first answer is you should absolutely do that. You should start having the conversation of what we think would be material, so it doesn't catch us unawares. The SEC won't be bound by that. Yeah.
I'm Gary Warner. I'm a research professor at UAB in Birmingham. And when I'm teaching about this, I always say that people apply the CISO playbook when you have a ransomware event or a breach. Lie, get caught, lie some more, get caught again, lie some more, get fired. The question with regard to this is when they come back the third round and say, oh my God, it wasn't 1,000, it was 1,000,000. And oh, actually, yes, they do have your social security number. They always say, we just realized that. Is that an out here? If they can give credible evidence that they didn't know the extent of the breach when they originally disclosed, is that legit?
So if the evidence is legit that I didn't know, I'm not held responsible for things that I don't know to the extent that I couldn't have known them. If I just bury my head in the sand and say I think everything's fine and Rome is burning, I will still face liability. But if I've got good evidence to say I didn't know that then, which is one of the reasons I want you to document it as you wander through, and it sounds awful, because if I've got the documentation, couldn't somebody subpoena that? The answer is, yeah, they're probably going to do it anyway. So you just get used to living a little bit more in the light of here's what we're doing and here's what we thought we needed to do. Great question.
Thank you.
Okay, I've got the stop thing there, so can I take these 2 questions? I apologize. They're going to start throwing things at me. So let me take these 2 questions outside and any others. And thank you so much for attending. Have a great conference this week.